SJC-11478, William J. Bower, meeting Michelle A. Bournay-Bower.
Good morning.
Have a seat, please. Yes, good morning.
Good morning, Your Honors. May it please the Court. My name is Susan Stenger. With me is my partner, Francine Gardikas. We represent appellant Michelle Bournay-Bower. We're here on direct review of a novel issue this morning. Your Honors, the appointment of a parent coordinator over a party's objection on issues of custody and visitation is in effect forced arbitration on matters that the legislature has entrusted to the probate court judges by statute.
May I ask you, is there a difference between, well, I know the words are different, but the notion, what about if this had been a master? And the judge said, I'm going to appoint a master in this case.
Yes, Your Honor. Masters are authorized by statute, and there are rules governing what they can and cannot do. Masters are often, special masters are appointed as a fact finder, and they will draft proposed findings, and they give a report to the judge. But the judge then accepts the report. It can send it back for more work. The judge can modify the report. The judge can reject the report. But it's the judge's ultimate. The judge is the person who makes the decision.
Now, in this case, didn't the judge say that the parent coordinator's conclusions will be binding unless I decide to change those findings?
She did, Your Honor.
So wasn't the judge saying exactly the same thing that you just told me the judges do with masters?
No, Your Honor, because...
Reserving final approval.
Not exactly, Your Honor, because she said, I give binding decision-making authority to the parenting coordinator, and the parties must comply with it unless and until they get before me and I issue a different ruling. Your Honor, the way the probate court works is it's very hard to get in on an emergency motion. You file your motion, the clerk says, okay, we have room for you 3 weeks from now or 2 months from now, and during that time, the parties have to comply with the parenting coordinator's decision. And very often, these are going to be 11th hour family matters involving medical care, discipline, religion, education, and the life events are happening.
Could I just ask a
very soon
clarifying question?
thereafter.
These normally don't come into play except in very high conflict custody situations. And this one is not by agreement of both parties.
Correct.
So first, are you only talking about those parenting arrangements that are by court order and not by consent of both parties? You're not suggesting that anything that you're arguing today also implicates consented to arrangements?
That's correct, Your Honor, and there are a couple decisions from the appeals court that upheld appointments of parenting coordinators where the parties had agreed to it in a separation agreement.
And you're not challenging that?
I'm not challenging.
And you're not, I'm trying to figure out what you are challenging, what you are challenging.
Let me back up. For my client, that's not really an issue, but I will say there's no structure for parenting coordinators. There's no official definition. There's no guidelines for training and duties and reporting. They really exist in a vacuum. And
That's my next question. So are you arguing that there should not be any kind of an order with respect to parenting coordinator in any situation because of those concerns, or because your case doesn't involve that? Are you just arguing that because there was a delegation of authority, that's your argument, that was wrong here, and that absent that delegation of authority, it would be okay?
I think it's okay if the parties agree, Your Honor, just as it's okay for them to agree to arbitration or mediation. They can set their own rules as part of the agreement. But I think part of the problem is if a party comes before a judge and feels pressured to agree to it.
Let me ask you then this final question before I let you go back or somebody else asks a question. So we're talking about very high conflict situations where children are involved, and there's been an agreement about, in general, about what the arrangement should be, and now I'm not necessarily speaking about this case, but generically, no one seems to be able to abide by the agreement. So how is a judge supposed to address, in the probate and family court, a very busy court, but these are very important situations, and whoever's got the child has the power until they get to court? What is the appropriate response for a judge faced with a recalcitrant parent who says, well, I don't agree, and so go to court. Is it contempt?
It is the contempt
Is it
procedure, Your Honor.
Holding in contempt and jailing? Is it forced removal of the children and transferring them to the other parent or to a third party? Is it calling DSS? What are the reasonable suggestions, alternatives to this?
I don't know if this is within the court's power on contempt, but certainly in modification, the judge could give sole legal custody to one parent where the two parents absolutely could not cooperate on any level. In terms of the contempt power of the court, Your Honor would know better than I, but there are certainly punitive actions that can be taken. I know imprisonment's a possibility for lack of child support payment. I've never heard of it in other contexts in the probate court. But contempt really is the vehicle by which this should happen. I'm not saying, I mean, could a parenting coordinator be appointed as a mediator, a facilitator? That's a different question. If that person has to be paid, there's still the issue of the cost to the
There's the
parties.
payment and the binding nature.
Yeah, the binding nature is my biggest concern.
Can I ask you something about that?
Yes.
I'm just looking at the order. When the judge says it's going to be binding authority unless either party dissatisfied comes to court before the decision is to take effect, and I understand that's a problem in itself. Do you read that as meaning that's the only time? In other words, do you read that as meaning if you don't, if you don't or can't challenge it before it takes effect, you're out of the ballpark?
You're out of the ballpark, you have to comply. The other thing is,
Well, I understand you have to comply for a while. I mean, you have to comply, but you can ex post facto challenge it, you think? In other words,
well, it might be moot by then. You know, could you, it might be helpful to say I'm not in contempt because that order was improper or something, but in fact it says the order is in effect until the judge changes it.
And are you suggesting that a lot of the things that the parent coordinator is going to be deciding are things that come up and have to be resolved quickly, and then they're over?
Exactly.
Who gets who, when, where, who goes to what show, how
Travel arrangements,
that kind of stuff, sort of hard to redo weeks later.
impossible.
But let me ask you this. So what did the parent coordinator do here that trumped in any way an existing order of the court?
Well, Your Honor, the parties reached a separation agreement on all issues except for summer vacation and Christmas vacation. They presented their agreement to the court. The judge heard long, vehement arguments from both sides on their positions, and then she made a decision and entered a schedule for the summer vacation.
The judge did?
Yes.
Okay.
The parties are from out of state. Their extended family is in another state. They have a vacation home there, and the mother was going to take the 4 children there for the summer. The husband, this was the issue they argued to the judge. Husband didn't like the decision. He filed a motion to alter and amend the divorce judgment. That was denied. Several months later, he files a complaint for contempt. The judge, instead of hearing the merits of any contempt, the judge appoints the parenting coordinator, and then the husband takes his issue about summer vacation to her. The wife, because it was on the eve of when this vacation was supposed to happen, she agreed to change the scheduling, feeling she had no choice. That if
Parent coordinator, or no, the
parent
spouse.
coordinator was involved but didn't make the decision. The wife agreed to change the schedule before there was a decision. And I say this is not relevant to the decision you have to make. It's just an example of what can happen, which is that she had her tickets, it was time to go, and if she had to stay and fight it in court, she would have spent her vacation time with her children litigating instead of being at the lake, and so she caved.
So the parent coordinator did not make a decision which was contrary to any existing separation agreement or court order?
No, but the father was asking her to modify the vacation schedule, and our position is he should have done that through a complaint for modification, which would have required him to meet the legal standard, which is proving a material change of circumstance.
So the father was asking the parent coordinator to change a specific term that the
The
court had
summer
already
schedule,
ordered?
who had what week and who had how much time. He wanted more time, and there were significant changes to it.
what
You know,
summer
what
was
I
that?
don't understand is this. You started by saying how busy the probate court is, how hard it is to get in to see a judge. Let's say you prevail here, so the judges can't use parent coordinators. what does that do to the parties who have cases? Now, they're not going to have a coordinator to resolve these matters. They'll go to court and they'll sit and they'll wait to get in before a judge, and if it's as busy as you say it is, they're not likely to get any relief, are they?
Well, hopefully judgments, it's an impetus for
But
judgments and
if the
agreements.
judge decides, instead of using a parent coordinator, I'll use a master, would that resolve it?
Well, but Your Honor, a master is appointed in connection with a pending action that has a purpose to it. The parenting coordinator is appointed in a final judgment to exist and hear these matters in a vacuum until the children reach the age of majority, absent an action for modification to
But you'd
remove.
rather have it that the parties just go to court and take their chances on when they can get in to see the judge?
They have a right to have the judge make the decision, and I also think going to a judge detracts frivolous issues from getting into the courtroom. It decreases the amount of frivolous issues. If any parent can take any little issue to the parenting coordinator, and the parties have to share the expense, one party who's more financially well off is putting an unfair, unconstitutional financial burden on the other parent to have their matters decided. The order here requires them to take these issues first to the parenting coordinator, a paid third-party neutral, before they can bring it to the court.
Although in this case, the husband was paying for Dr. Deutsch, right?
He was, Your Honor, and, but there's a significant argument in the amicus brief filed in this case.
I understand, I mean, it's a real argument,
Yeah.
it's a real issue, I don't deny that, but just here, that
In
wasn't.
this particular
yeah.
case, that wasn't the issue. However, the order said the father shall pay for it unless the parenting coordinator tells the judge that the mother's misbehaving. So that puts a really unfair leverage in the use of the parenting coordinator and the cooperation with the parenting coordinator, because the mother's got a financial penalty hanging over her head if she.
Well, presumably, that's something that the judge would have to impose. The parent coordinator can't say, I'm changing the rules here, and now you pay. The parent coordinator can't say that.
I agree with that, Your Honor, but having that hanging over her head will affect her actions in dealing with the parenting coordinator and maybe not raising positions that she's entitled to raise.
Do you think, I'm following up on questions that Chief Justice Ireland asked you. In a situation like this, would you have a difficulty if the judge appointed a parenting coordinator, even though you've got one party who doesn't really want that, but the rules of the game are if a party is dissatisfied with the resolution that the parenting coordinator arrives at, he or she can come to court. In other words, it operates until somebody's unhappy, and then it is not the final order.
What's the question?
The question is, would that, if you had a parenting coordinator operating under that regime, where a disputed decision by the parenting coordinator, instead of going into effect, would not until a judge heard it?
Is that acceptable?
Yes.
No, because until the judge hears it and makes a decision, which could be weeks or months, the parties are bound by that
No,
decision.
I'm asking you, forget this order. I'm asking you, if the rules of the game were that the parenting coordinator was available, could solve these interstitial problems, but if one party or the other objected to the resolution of the particular problem, he or she, before that decision went into effect, he or she could go in.
If it were in fact not a decision but a recommendation, and that, or
The decision, unless somebody turns it into a
right,
recommendation.
the
Right.
parties could either agree to it or it has to go to the court to be approved. That would work. That's more
Like a
akin to a
GAL,
GAL
yeah,
report.
exactly.
Yes.
But, so in other words, take this binding authority language and just strike and obtains a contrary order. And that's, I think, what Justice Botsford is suggesting.
Yeah.
It's binding unless someone goes to court. If they go to court, in other words, file something in court, it's not binding until there's a decision by the court. Just drop out the last few words, and don't you have exactly that?
Well, if there's time. So for instance, if the parenting coordinator issues a decision on a Friday afternoon regarding an event to happen that weekend, there's no time to even file something in the court. If what you're saying is filing in the court would stay the order, that's a lot different than this saying you
No,
have to
I'm
get a
just,
decision.
what we're asking whether that would be an adequate way to proceed.
If there were time to file, I think there are myriad situations where there wouldn't even be time to file.
This is one of the reasons why there's a parent coordinator, because there is no time sometimes.
Well, but then there's also the cost issue.
Counsel, your time is up.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. Lisa Ruggieri on behalf of the father, appellee, Mr. William Bower, who's sitting in the courtroom today. I will be addressing the first 9 minutes of the argument as it relates to whether or not Judge Harms exceeded her authority, and co-counsel attorney Jocelyn Thompson will be addressing some issues raised in the amicus brief. So the only real issue before this court is whether or not Judge Harms exceeded her authority. Judge Harms knew the Bower family for 3 years when she made this appointment. Judge Harms exercised her broad and flexible powers to fashion a remedy that was in the best interest of the children. She used a general equity jurisdiction, and she exercised proper judicial discretion. She didn't delegate her authority to Dr. Deutsch in this matter. In fact, her order clearly states that the parties would follow her decision in the first instance, which would suggest that if either party was dissatisfied, they still had a right to come back to the court and then have the issue heard before the judge.
But
in
the
second
timing
instance.
issue is an important one, right? Because how do you get it, they're stuck with the decision of the parenting coordinator unless they can get not just filed a disagreement, filing an objection to it, they have to get it resolved and get a contrary order. So, that's a pretty high standard. It's a pretty tough burden for somebody to have.
Well, I think the intent of this is to provide a remedy that's in the best interest of the children. And what's happening when you have a couple that cannot co-parent is it's to the detriment of the children.
Maybe you should just not have it be joint legal custody.
Well, that would even, I believe that would make the couples even more contentious. In other words, hopefully someone like an appointment like Dr. Deutsch. This is about Judge Harms knowing this particular family for 3 years, knowing the facts and circumstances, and appointing a parent coordinator such as Dr. Deutsch, who had the sophistication and backbone to not just issue rulings and decisions, but to help the parties communicate and help the parties compromise. In fact, during the pendency of Dr. Deutsch's role, it was working, and the parties did just that. Father was able to attend the child's confirmation and sit in the family pew that he otherwise would not have done so because it just wouldn't have happened. They actually modified the summer vacation plan. There wasn't a decision, it was actually an agreement. In fact, it was beneficial for Mother because what Dr. Deutsch did was Mother was allowed to actually leave when the kids graduated from school rather than waiting, and Father actually was able to take his vacation sooner.
Well, if Mother was so happy with this, why is she contesting it?
Well, I believe it.
Sounds like Father's really happy with it, but that Mother isn't so keen on this.
Well, Mother preferred not to use the parent coordinator. Mother's position was she preferred to go before Judge Harms because Judge Harms was familiar with the family. However, that's not always appropriate. The courts are strapped, and the courts cannot deal on a day-to-day basis implementing daily parenting plans, tweaking holiday schedules and summer schedules, and dealing with telephone access to rights to the parents when it's on the other parent's parenting time.
Can I ask you this? So is your argument here that it's not an abuse of discretion because the judge had significant familiarity with the circumstances and at the end of the day used her judgment that this was an appropriate mechanism to try to resolve the myriad of problems that kept arising?
Yes, without any statute or regulation or law concerning parent coordinators right now.
So it might have been an abuse of discretion if case comes before Judge Harms and she says, my experience is parent coordinators are great. I'm just ordering a parent coordinator. without any real experience with the family or the back and forth, that might be an abuse of discretion?
I don't believe a parent coordinator is necessarily the remedy in every single case, nor is it appropriate in every single case. But in this particular case, with the Bowers and many other cases, when you have high conflict couples, the only solution that a court can provide is a parent coordinator.
So could we have parent coordinators in highly contested cases and just routinely say, this is a highly contested case, so we'll assign a parent coordinator?
Again, I believe it's within the judge's discretion to determine whether or not a parent coordinator is appropriate in a particular case. Judge Arms clearly recognized when the parties came in with cross complaints 6 months after their divorce was final, with 17,000 issues, she can't turn back time and figure out what happened. There was no retroactive relief. She could not then say to father, I'm sorry you missed preschool graduation. I'm sorry you didn't get to attend a teacher conference. I'm sorry you didn't get to go to orthodontist. There is no retroactive relief.
So could she have appointed a parenting coordinator if neither party wanted it and simply said, you'll have it and you'll both pay for it?
Well, I think
Within her authority to do?
I think it's a practice that happens regularly.
In her authority to do this?
If in fact this case has called this court's attention because one party has objected. But to require mutual agreement between parties that cannot agree invites the same type of impasse we're trying to avoid.
But is there any other context in any other court in which a court has the authority to order somebody to be subject to the decisions of somebody else?
She did not delegate her authority in this case because her order clearly states in the first instance, which means either dissatisfied party still has the right to come before the court.
They have to get to the court before the decision is to take an effect. So
But these aren't substantive issues. We're not talking about changes in custody or
but would
religion.
you agree that you can't get to court before the decision takes effect in many, many, many instances that the parenting coordinator would be dealing with?
I would agree, but then what would happen to the opposite, the other aggrieved party? He or she couldn't get to court either. In other words, there needs to be, and without any dispute, with the dispute not being resolved by either a court or a parent coordinator, again, it's the detriment of the children. It's the children that are suffering here. And it goes back to a probate and family court having that authority to fashion remedies in the best interest of the children. And when parents cannot co-parent and it's dysfunctional, it is the children that suffer. And that is why, in this particular case, especially with someone with the sophistication and backbone of Dr. Deutsch, who while it was working, they were actually reaching compromises. There was no decisions made by Dr. Deutsch. She was able to educate them, they were able to communicate with each other, and they were able to reach compromises on the issues. And if the issues weren't important enough to bring to the parent coordinator, they wouldn't bring it to the parent coordinator. If they learned to resolve their own disputes, there's no need for a parent coordinator.
But the argument you're making suggests that what's appropriate for the parenting coordinator is to be a mediator, not to have binding authority.
Well, the argument would be in the event the parent coordinator cannot get the parties to compromise and resolve their own dispute, then in that instance, someone such as a Dr. Deutsch would then make a decision. If either party was dissatisfied with that decision, clearly they still have that right to review in court. That decision is not going to be devastating because it's not a substantive issue. These are tweaking and fine-tuning within the agreements that are already in place. It's certainly not to modify existing judgments.
So if the parenting coordinator makes a decision and there's just not enough time to go to court, what does it mean that there's not enough time to go to court? I mean, can they go to court and is the issue moot?
Well, clearly, if in fact it was a decision that was totally inappropriate, either court could clearly get into court on a short order or an emergency notice. Clearly, it's unlikely that the couple is going to wait to the very last minute for a decision to go into the parent coordinator. It's a decision that they know is a dispute. They would have scheduled an appointment, and they would have had an opportunity to address these, whether on a telephone call or in a meeting.
And if they can't, does the mootness doctrine apply?
If they can't resolve the dispute?
Yeah.
Well, then the parent coordinator in this particular instance would have the authority to make a decision. Again, it would be in the best interest of the children, because
Yeah.
without that decision, it's to the detriment of the children, ultimately, because it's all dealing with child-related issues. They're dealing with issues of whether or not tweaking a parenting plan and telephone access, not substantive issues. The appeals court,
Your time is up. Thank you.
thank you, Your Honor.
Good morning, Your Honors. Jocelyn Thompson, co-counsel for Mr. Bower. Unless the court would like to continue with any of those specific questions, I was going to begin by discussing some of the counter-arguments that were addressed and some of the constitutional issues that were raised in the amicus brief.
Well, how about what other states do in handling this? It seems to me that there's a pretty strong view by some states that it is either going to be done by legislation or by court rule, but not on a judge-by-judge basis.
The states go in all directions in this instance. Some states have absolutely denied that parent coordinators will ever be in place. Other states are putting them in place, and they are highly regulated. However, they are highly regulated. Some states have determined that it is too difficult to regulate, so it will not be appropriate.
When you say it's too difficult to regulate, have studies been done about the effects of the parenting coordinator process? Is it generally successful, unsuccessful?
Yes. What is successful is that instead, in lieu of the parties living with controversy and waiting for their next opportunity to go to court, they have a remedy. They have an option, an opportunity for some relief that is available that can allow them to get on with the business of taking care of their children. And studies have shown that children who live with the constant stress are more subject, are affected detrimentally, unlike children where the stress is relieved where the stress is relieved more readily. And in fact, that's really why Judge Harms put this order in place, because it was her obligation as a probate and family court judge to provide relief, to provide a remedy. Specifically, she has not only statutory authorization in the probate court, but also an inherent power to take action necessary to provide relief and remedy for the people who come before her. And she had come to the point where she was no longer able to provide relief for Mr. Bower.
But
The issues were retroactive.
Surely those powers don't include giving up her powers as a judge and simply assigning them to someone else.
No, they do not, no. And we give due respect to the language of her order, in that her intent is clear and there is limiting language in there. First, the word of dispute. What she intended with the parent coordinator to address was disputes, the day-to-day disputes.
She doesn't say that. She just says all disputes between the parties regarding custody and visitation. All disputes, including the big ones as well as the little ones.
Well, we would like to suggest that the final clause where she says that provides parties the rights to return to court
They have
if
to get in a contrary order before you have to actually get the order, a contrary order. And until then, what the parenting coordinator does is binding.
yes,
And that's pretty extreme. As to all disputes
as to all
between the parties
disputes.
regarding custody and visitation.
A party in an emergency, again, as my co-counsel said, will be able to obtain access to the probate court on short
Could I
notice.
go back to that question that is raised by Justice Lang's question, and that is, even though it says all, isn't there an understood, even if we don't have a statute, but in the literature, isn't it understood, or is there an understanding about what it is that a parenting coordinator does and does not do? That is, do they act within a certain ambit, that is, the confines of a judgment or an agreement? Or is it any and all, such as, okay, now you don't get to have a month's vacation, we're going to change that? Or is it, oh, the order is for a month's vacation, but you have to leave a day sooner because it's your Aunt Tilly's birthday, and you've bought the tickets even if you didn't ask the other side.
Yes, Justice Duffley, you're correct in that it is an understood concept that substantive judicial decisions, such as modification of custody, such as changes of visitation orders, the content of a parenting plan, those are judicial making authority, under the authority of the judge. The parent coordinator is there instead to solve those problems, as you said, whether
I was more
Aunt Tilly
asking if that
comes
were the
into.
case. I don't have a lot of experience with parenting coordination, actually. So I'm learning as I
They can be
listen.
they can be very effective. Again, as.
Doesn't that get taken care of if there's legislation or a court rule or something that sets out what the parameters of a parenting coordinator's responsibilities and role are? And we don't have anything like that here.
We have nothing like that, and this is one area where mother, father, and the Friends of the Court all agreed that there is no rule, no regulation, nothing defining or giving any parameters to the qualifications or the rules or how a parent coordinator is appointed.
So I take it, with my earlier question concerning mootness, if mootness in fact does apply, it's only because, and I don't mean to minimize this, it's only because the decision that was made by the parenting coordinator is not a structural decision with respect to the relationship. It only affects a particular event.
An event, exactly, that would arise in one day and maybe over in one day, something that may occur on a weekend. And as the judge said, any party still has access to the court if they disagree with that decision, unless the decision has already taken effect. We suggest that orders that change custody, that change parenting plans, serious complete modifications do not occur over a weekend. That event will not have been passed on
Counsel,
over
we
a
have to
weekend.
leave it there.
Thank you.
Thank you.
Thank you.